Hello everybody, and many thanks for inviting me to give this presentation here. I'm excited to talk at this conference and very sorry that I'm not with you in person. I would have loved to discuss these things with you, but unfortunately I will be in Denmark when the conference is happening, so I can't be there. But in any case, I will normally be in Oslo and open to discussions, and if you think that there's something interesting to talk about afterwards, then I would be happy to hear from you and also to see whether there might be things we might do together at some point in terms of future research on AI. I'm a lawyer and I'm going to talk about AI laws, and particularly a law that is upcoming in Europe. And for me, doing research is probably a little bit different from what most of you are doing, which might be more hands-on in terms of developing AI. I'm trying to understand AI, but I'm also trying to understand how it could be regulated, how it should be regulated. So the types of questions that we lawyers ask might be a bit different from the types of questions that you may be asking. But I do hope that what I have to say is relevant for you. And I think that certainly much of what I have to say will have a bearing on things you will do in the future, because it is likely that we soon will have a new law in the EU that will focus on artificial intelligence, and that some aspects of that law will apply to what you are doing. And the main question for me today in this talk will be whether Europe's upcoming AI law will apply to AI research. And I can perhaps already start with the answer to that question, and that is that things are not fully settled at this point. The law isn't finished, so we don't know what will be the outcome, but most probably there will be an exception for research, which means that the law will not apply to AI research as such. But if you are developing AI that somehow may be put on a market in the EU, then it will nevertheless apply. So in a sense, I'll get back to that at the end of my talk. In a sense, if you're only doing research and never think that any of what you're doing may have some practical applications, then you are probably safe. But I guess that at the point of time when you're doing research, it may be a bit difficult to decide whether what you are developing may have some practical applications in the future, which is why maybe the law has application to what you're doing nevertheless. But I'll start by briefly introducing what the law actually does, what the law wants to achieve, and also what the consequences are of not complying with this law, to give you an idea of what might be coming. And then I'll go through the specific requirements that will apply, and also the degree. At the end, I'll discuss the degree to which AI research as such is also regulated by this law. Now, the title of my talk is about an upcoming AI law, and that is because at this point the law is still being negotiated. In 2021 there was a proposal by the European Commission, and then there are three lawmakers in the EU: the Council, which is the representatives of the member states, and the Parliament and the Commission. These three need to negotiate, in a sense, what will be the law, and they haven't finished in doing that. So at this point we have different ideas about what should be in the law, and I will primarily focus on the original draft which was proposed by the European Commission in April of 21. But it remains to be seen what exactly will be the final outcome of this lawmaking process. Before I'll address the proposed law, I first need to explain a little bit of the landscape that this new law will come into. And the first part of that landscape is perhaps something that you may be a little bit familiar with. That's the discussion about AI ethics. In the EU, there has been a focus on AI ethics and ethical principles for AI. You may remember the work of the high-level expert group. That was an attempt to avoid regulation, because regulation can perhaps stop the development of AI, and one wanted rather to have some ethical principles which are non-binding, and through human oversight, transparency, and accountability and principles like that facilitate the development of trustworthy AI. However, in recent years, the winds have turned, and the Commission now thinks that it's much better to actually have a real law that is binding and that everybody has to comply with. So many of these ethical principles are now then translated into legal principles, and that's where the new law comes into place. Okay, so that's the first element, the ethical principles. And then the GDPR is perhaps worth mentioning. GDPR is an existing law. It's called the General Data Protection Regulation. You may have heard about it. It deals with data processing, data protection, so personal data. And all the rules about personal data can basically be found there. But that law also includes rules about automated decision making. That's also something where AI can be used. So we already have some existing laws that apply to AI when you are using personal data, and also when you use automated decision making. And what is characteristic for this law is in part its focus on risk, and also that compliance is super important, because if you don't comply with the GDPR, then you may be fined, and that can be quite expensive. So the GDPR is an important part of the existing legal landscape for AI, but it's not something I'm going to talk about anymore in this talk. Then we have another field of law, which is liability law. This deals with the question, what happens if something goes wrong? Who has to pay? And so existing rules deal, for example, with the question of product liability. If my phone explodes, what happens then? Who can be held liable? And then there is a discussion about AI and liability, but those rules haven't even been proposed. We expect that there will be rules about AI liability discussed in the EU in the second half of this year. So at this point, I can't say much about it, but perhaps we can revisit this question at a later point. And then perhaps another aspect of that landscape can be called product safety. That is rules about when products are safe enough to be put on the market. Think about toys, for example. Toys are marked with a little CE mark, hopefully, which means that they are safe. So, for example, a part of a toy shouldn't come off so that a kid could swallow part of the toy and then get some breathing issues. And also for machinery, such as robots, there are rules about safety for medical devices. If you have a pacemaker, then that has to be safe, obviously, and those safety rules are in the medical device regulation. Now, this is the most important part of that landscape, because this is very close to what this new law will actually address, because it's simply thinking, It's adopting the basic approach from product safety laws and saying that, okay, what requirements does an AI system have to comply with in order to be safe so that it can be put on the market in Europe? And safety is obviously a challenging and difficult question, and that's why in many of these existing laws and also in the new law, technical standards play an important role. And that's also, I think, quite relevant for you because I assume that many of you are dealing hands-on with AI development, and you are much more familiar probably with technical standards than with the law. And then by complying with technical standards, you can often be presumed to also be complying with the law. So that's an important feature of this law. Now, as you see, the landscape is expanding with this pyramid that I have put in here. And this is really taken from a slide by the European Commission about the main approach of this new law, and it's a risk-based approach. So that means that AI systems are regulated differently depending on their risk level. So if something has a very high risk level, such as unacceptable risk up here, then it's forbidden. Or if some AI system has a high risk, then certain rules actually apply. And then if it's limited risk or minimal risk, then there are actually very few rules. So actually, understanding the AI risk is quite important. So that's why I have put this pyramid here to, in a sense, visualize how the landscape is expanding with this new and colorful mountain, which looks quite different from some of the other rules, but it's quite similar to the product safety rules. And the existing approach of product safety is applied in the field of AI. And so in this landscape, we have another mountain which we will climb, and there is even a sun, the CE mark that you may have seen on certain products, signifying that the product is safe. So that's in a sense the basic idea with this law, putting up some requirements for safe and trustworthy AI so that it can be put on the European market. But in order to regulate AI, we actually have to define it. And you might find that a bit strange, but think about it. If AI systems should be regulated, we have to understand what are actually AI systems and how can we distinguish them from other systems, from other software. And so the starting point for AI systems in this new proposed law is that the draft talks about basically 3 technologies: machine learning approaches, logic and knowledge-based approaches, and then statistical approaches. And you may see that, okay, there is some overlap there, but there are also some questions about what exactly does it mean that there is logic programming, for example. So these are quite difficult, at least for a lawyer, these are quite difficult distinctions. And just by mentioning these technologies, it's not sufficient to say that, okay, this should be the AI that we are regulating. We need a little bit more. And this more is a text that is included in the law. And here it becomes a little bit complicated because there are different versions of this text. Now we have first the version of the European Commission as it sees this AI system, and it says that AI systems mean software that is developed with some of these techniques that we saw on the previous slide, and which can, for a given set of human-defined objectives, generate outputs, such as content, predictions, recommendations, or decisions, influencing the environments they interact with. So in a sense, it's software. It uses some of those techniques that I showed you, but exactly distinguishing what is within these techniques and outside is a bit difficult. But then we have objectives, and for these objectives, human-defined objectives, there are outputs which are influencing the environments they interact with. And here it becomes challenging to distinguish what exactly are we actually talking about, and how do we know whether something is an AI system that is regulated under this law and some other software which is not regulated. Let's take the example of a lift. I press a button and it can bring me to the 17th floor. Now, is that something that is an AI? Maybe there is some logic-based programming that connects. I don't know how lifts are programmed, but if we assume that perhaps there is some logic in the software that defines how this lift is used, I have this human-defined objective that if I press button 17, then the output is that I am brought to the 17th floor. So, but you see that here we get into real trouble when we basically regulate everything, every type of software as AI. That can't really be the solution. So we need something that is a little bit more limited. And that is the second perspective in the regulation of artificial intelligence, and that's the version of the Council. So the Council is the representation of the EU member states, so Germany, France, and so on. They sit in the Council and they look at the proposal and say, well, it looks like everything will be, every kind of software might count, legally speaking, as AI, and then it would be suddenly subject to lots of requirements. Maybe that's too broad. So they have put forward a different proposal, which says that, okay, it's a system that receives human-based data and input. Okay, I press the button, and infers how to achieve a given set of human-defined objectives. So this inference is relevant here, using learning, reasoning, or modeling implemented with the techniques listed on the previous slide, and then generates outputs which influence the environments the system interacts with. So this inference here is perhaps the element that distinguishes the AI system from the other systems. If that is sufficient or not, time will tell. But at least the general problem that we lawyers have here is that we have to define something that is then the object of the law, which is the regulated thing, and we have to define it rather precisely because we need to later be able to distinguish between other software systems which are not regulated by this law and those AI systems that are regulated. So this is for the lawyers, this is a challenging endeavor. So now we have a preliminary understanding of what the law considers is an AI system. And as you might understand, lots of things can be AI systems under the law. But then the problem is that maybe by regulating all of these, the law would be too heavy-handed. And the idea, therefore, is that let's distinguish different types of AI systems. Let's distinguish high-risk AI from low-risk AI, and then based on that distinction, introduce rules. So some rules for high-risk AI, fewer rules or no rules for low-risk AI, and if the risk is really unacceptable, well, then it has to be forbidden. And that's exactly what the EU is doing. So let's start at the top of the pyramid, and that's where the highest risks are, so the unacceptable risk. And of course, if something is unacceptable, then it has to be forbidden. And there are a few prohibitions that we can mention. The first one is really perhaps the most challenging to understand, because it deals with so-called subliminal techniques. That's basically where you're manipulating someone and you're using those techniques beyond their consciousness and then probably cause harm. So this is a really challenging part of the law where I haven't been able to really find good examples. So maybe that's a bit futuristic, using subliminal techniques, AI techniques, to influence and manipulate a person beyond their consciousness. For those of you who have watched many futuristic movies, science fiction movies, maybe you can come up with something there. But so for now, I think most of you would probably not violate that prohibition. So that should be fine. Now, the second prohibition is probably a bit easier to understand. And that's an AI system that exploits the vulnerabilities of a certain group of persons. Let's take, for example, kids, their age, or people with mental disability. So vulnerable people, and if their behavior is materially distorted, and that then can create physical or psychological harm to those persons, then that should also be prohibited. So again, we are seeing something that is really problematic, exploiting the vulnerabilities of a vulnerable group in order to distort their behavior. So most likely, hopefully, none of you are in danger of violating this prohibition. The next one is interesting because it's perhaps inspired by Chinese examples of AI, where you have social scoring for general purposes in society. And so then if you help the poor or engage in charity work, donate blood, then you get some extra credits. And if you do something that the Communist Party doesn't like, then you maybe get some negative points. And then maybe you don't have enough points to actually book a plane ticket or a train ticket. So those kinds of general scoring for general purposes, that's something that is prohibited under the law if it is adopted. And an interesting discussion there is whether that prohibition should only regard public authorities or also private parties doing a general social scoring. The next prohibition is about real-time biometric identification systems. So you walk along the street and you are being identified in publicly accessible spaces for the purposes of law enforcement. And that is prohibited unless some exceptions. And of course, this is a huge discussion point because there are some entities, police forces, for example, that argue that we need more of these remote biometric identification systems, while privacy advocates perhaps say that we need less of these. Okay, those were actually already all the prohibitions that I had to offer. And you see that most likely none of the systems that you are developing falls under these prohibitions. So you are fine. But what is if your system is classified as high risk? Because if it is, then it's not forbidden, but some rules will apply. And we'll have to look at what exactly these rules are. But in order to get there, we first need to understand what would it be for an AI system to be high risk. So how can we distinguish high risk AI systems from non-high risk AI systems? Let's think of, for example, let's take the example of my spam filter. Let's say that uses some form of AI system, then, but it's not really problematic. It's not a big deal. It's just helping me to sort through my emails. So we need some criteria and some examples to actually understand what should be the regulated AI systems. And there are basically two approaches there. One is AI systems as safety components in some products. So if you have a product, a physical product, such as a lift, maybe again, then and then there is an AI that is the safety component, then it's high risk. But then also standalone AI systems, which are used for specific purposes. For example, your exams are graded by an AI. That would be an example of a use case that is also considered high risk. So let's first look at the first example, safety components of some products. And that's really where we have existing laws. For example, for medical devices, I mentioned the heart pacemaker, but many other medical devices would be regulated. And so if the AI is a safety component of such a product, and you under these existing rules, let's say for example for medical devices, you have to do a third-party prior conformity assessment. So for example, the pacemaker is really a dangerous object because if it doesn't work well, I could actually die. That's why the producer of the pacemaker can't just say, well, we are complying with all the rules, it's all fine. They have to ask a third-party agency to check the product and make sure that's actually safe. So it's an additional safety mechanism there. So, and those products, if the products are so risky that they are that you have to ask a third party to certify its safety under a list of rules, then you add the AI as a safety component in that product, then you would have something that is regulated under these rules. So far we're not talking about what the rules actually are, we're just trying to understand which systems the rules would apply to. Okay, that was the first example. So product, sorry, the heading here is in Norwegian. I gave this talk in Norwegian before. So products which have are related to an AI, and it's the safety component of the product. Now, in the second group is basically standalone AI system. It's just the software, not put into any program. And I mentioned the example of exams being graded. That would be one part, one example. Education and vocational training. But also if you have an employment situation, you're applying for a job and you are first being interviewed by the AI. That would be a situation which is considered high risk because you maybe the AI discriminates certain groups of people, and then therefore it should be regulated. The same is true administrating of justice. If we have an AI judge that decides your case, then we want that AI system to be extra safe. So as you see, the commission who developed this framework, they try to come up with certain use cases which maybe you have heard about already, which are problematic, and they are so important for society that they have to be regulated. So my spam filter isn't in here. Another thing that isn't in here is, for example, are the algorithms that Facebook uses to push certain content to you. That's not something that is high risk under this law. But there are other laws that deal with Facebook, and those laws would also deal with AI used by Facebook. So we are only here talking about the specifics of general AI systems which are standalone and which are being considered as high risk. So, okay. So what we've seen so far is that we have some systems that are considered as high risk, and then those systems are the object of regulation. And importantly, it's also possible for the Commission to come up with an update of this list. So if there are new systems developed in the future that could be considered high risk, then they can add something to this list. And important is also to distinguish, to talk about what is it actually, how do we define whether something is an AI that is meant to be used for education purposes, that will grade papers, for example. And that's really decided by the provider. And so it's the intended use. That means that if you're developing a general purpose AI system, then it's not considered as an intended purpose within this regulation. So if any of you are working on general purpose AI systems that are not meant for these purposes, then they are not high risk, probably. So now let's talk a little bit about what are the consequences of something being a high-risk AI system. And that's basically the requirements that you have to comply with. You have to manage the risks, you have to do a risk assessment, and you have to deal with the data in a way that is compliant. So you have to manage the data in a good way in order, for example, to avoid biases in the data, those kinds of things. Third is you have to deal with technical documentation. You have to produce a lot of technical documentation and also record keeping. So you have to log what the AI system is doing. And then there are rules about transparency. You have to give information to the users. Transparency is obviously a huge issue in AI. And also the same applies to human oversight, which is a huge issue. How do you ensure human oversight over AI systems? And last but not least, accuracy, robustness, and also even the cybersecurity of the system has to be ensured. So all of these requirements, I can't unfortunately go into depth with respect to them, but they will need to be specified, and that's where the technical standards come in. So probably we'll have some technical standards that you can comply with in order to ensure compliance with these rules. But that would be specific technical standards which are drafted after the law has been passed and which are then so-called harmonized standards, and which will give you the specific requirements you have to comply with. Just very briefly, the limited risk is a special category which is even below the high risk, but it's not zero risk basically. And that is related to a specific type of AI, which are chatbots and deepfakes. And so the only rules about chatbots and deepfakes is that you have to tell the user that this is a chatbot, and you have to tell the user that this is a deepfake. Make clear to humans that they are AI system. So that's basically the law saying that, hey, I'm a robot, I'm not a human being. Obviously, there are exceptions there, unless it's obviously, or maybe for law enforcement purposes or freedom of expression, freedom of the art, the like. So that's the only rule that applies to chatbots. So all chatbots have to comply with these rules, even though they are not necessarily qualified as high-risk AI systems. And now let me get to the final point, and that's really how does this apply to you if you are doing AI development in a research context. And that is something that is still not fully decided. But the latest version of this law, the latest proposal of this law, does actually say first that AI systems, including their output, that are meant to be specifically put into service for the sole purpose of scientific research, they are not regulated by this law. So if the AI is only meant for scientific research, then this doesn't apply. And also, interestingly, If you are doing research, any research and development activity regarding AI systems are not regulated, not affected by this law, insofar as such activity does not lead to or entail placing an AI system on the market or putting it into service. And that's basically what I mentioned at the beginning, that if you don't know whether you ever will put your AI system on a market in the EU, then make sure that you comply with these rules. And my basic suggestion would be to try to comply with as many as possible of these rules anyway, because you don't really know what will happen perhaps at later stages of development. If you think that maybe you'll put your system on the market, and if it might be considered a high-risk AI system and then would be regulated, then consider complying with these rules. But even if you're not considering putting it on the market, or not considering or your AI system might not even count as high risk, then you might still consider whether you should comply with the specific rules of the AI regulation as far as they are current best practices. So if and to the degree the requirements here are just best practices, then why not comply with these rules anyway? So hopefully I've given you some ideas about what might be coming here, but as I said, the future will tell what will be actually in this rule, in this law. So we'll see what happens in the future. Thank you very much for attending this talk, and I wish you a nice conference.